Hi everyone. Today we will talk about standing or LOCUS STANDI for judicial review in the UK and compare it briefly with another common law country. First, what is judicial review? Judicial review is when courts check on public authorities follow the law or not. The court does not decide the decision of the case is right or fair, but just whether it is legal. Standing asks, do you have the right to bring judicial review? Not everyone can challenge government decision. The claimant must have a real connection or interest in the issue. Why is standing important? It helps filter out pointless cases to protect the court's time and ensures serious government wrongdoing can be challenged. There is a tension here. On one side, we want access to justice so people can stop illegal government action. On the other side, we need to prevent misuse of judicial review by people who have no real stake. Historically, only people directly harmed, like property owner or taxpayer losing money, could bring up claims. Public interest groups were often refused. Over time, the sufficient interest test allowed individuals and NGOs to challenge government's action as long as they had a genius connection and could contribute meaningfully. Today, standing is flexible but controlled. Courts allow cases with real interest, expertise, or representation, but aspects of political claim are still limited. In this presentation, we will see how standing developed in the UK and compare it with another country.
Historically, the UK applied a very narrow and individualistic model of standing. Court require a claimant to qualify as a person aggrieved, meaning someone who suffered direct personally, financial or property harm. Judicial review at this time focused mainly on protecting private rights, not on ensuring public accountability. The Attorney General was treated as the exclusive guardian of public rights, while ordinary citizens had almost no ability to challenge unlawful government action affecting a wider public. As a result, courts were highly suspicious of public spirited individuals or groups who try to raise issues of legality. These claimants were often dismissed as busybodies. Judge insisted that only those with a direct personal stake could bring a case, fearing that broader access would open the footage to litigation and interfere with administrative efficiency. Mere concern for good governance was not enough to obtain standing. The strict model required proof of a private legal right being infringed or evidence of special damage beyond that the public experience. Despite this rigidity, a few limited exceptions appear. Courts occasionally granted standing to residents, ratepayers, or taxpayers, but only when they could show a direct financial or local impact. Individuals involved in administrative schemes such as licensing or planning sometimes gain standing because they were already part of the process. Very rarely, courts allow challenges where the illegality was obvious and serious, but these were inconsistent and did not signal a broader shift. Several cases highlight how restrictive the courts were. In Boyce v. Paddington Borough Council, 1903, the court allowed standing for people directly affected or ratepayers with financial interests, but this remained narrow. In Gore v. Union of Post Office Workers, 1978, the House of Lords refused standing to a private citizen challenging unlawful postal strikes, holding that only the Attorney General could sue to protect public rights. This reinforced the idea that public wrongs could not be challenged by individuals, even when the illegality was significant. This strict approach created a major structural problem. Many unlawful government action caused no direct harm to any individual, meaning no one had standing to challenge them. Judges and scholars describe this as a lacuna in the rule of law because serious public wrongs were effectively immune from judicial review. By the 1970s, criticism of the strict model grew, and it became clear and standing needed to evolve so that the court could address public law illegality even without personal injury. This paved the way for the more flexible sufficient interest test.
Hi, my name is Mark, and today I'll be talking about the shift between sufficient interest and the modern UK test. The quotes we've just discussed highlight a critical turning point in UK public law. The traditional requirement for standing, which demanded that a claimant demonstrate a unique direct legal right or proprietary interest affected by the unlawful act, was deemed too restrictive. The rigidity led to this legislative change, now codified in Section 31(3) of the Senior Courts Act 1981, which states that the High Court shall not grant leave to make an application for judicial review unless it considers that the applicant has a sufficient interest in the matter to which the application relates. This sufficient interest test fundamentally shifted the focus. Standing no longer tied to direct personal harm, the court is not primarily concerned with the claimant's private injury. The focus is now on the illegality itself, whether the claimant has a genuine real stake in ensuring the rule of law is upheld and the public body acts legally. As Lord Diplock argued in the National Federation case, it will be a grave lacuna if outdated technical rules prevented a public-spirited individual or group from exposing unlawful conduct. This is the progressive spirit of the modern test. The two-stage approach, procedure and merits. The determination of sufficient interest operates under a unique two-stage procedural framework. Number 1. Primarily preliminary assessment, the permission stage. When a claimant first applies for judicial review, the court makes a prima facie assessment. Does the claimant have an arguable case, or does their interest appear sufficient on the papers? This is a relatively low bar. If granted, the claimant is given leave to proceed. The second stage, final evaluation, substantive hearing. The ultimate decision on standing is intrinsically linked to the merits of the case itself. The court often asks, if the public body has committed a serious illegality, is this particular claimant the right person to challenge it? As the court stated in the National Federation case, it is often undesirable to separate standing entirely from the legal merits of the complaint. This fused approach means that a claimant with a weak interest but a highly serious case of illegality is more likely to be granted standing than a claimant with a strong interest but a trivial legal complaint. So who now qualifies as having sufficient interest? The modern test is flexible and accommodates several types of claimants, reflecting the public nature of the remedy. Individuals personally affected, the traditional claimant. This remains the easiest path. Anyone whose property, liberty, or livelihood is directly threatened by a public body's decision will always satisfy the test. Public-spirited citizens, the Lord Diplock claimant. While rare, a single highly serious breach of public duty can justify standing for any taxpayer. However, in routine tax matters, Lord Wilberforce's view still applies. One taxpayer generally cannot challenge another tax affairs, reinforcing the idea that an aggregate of individuals, each of whom has no interest, cannot of itself have an interest, unless the matter is of sufficient gravity. Legitimate NGOs and associations, the pressure group. This is the most significant development. Standing is now regularly granted to. Representation. Groups acting on behalf of their members, such as trade unions or local residents associations. Expertise or mission. Bodies like Greenpeace or the Child Poverty Action Group CPAG often gain standing even if they aren't directly affected, because of their established expertise, public profile, and dedication to the subject matter. A key case here is RV Secretary of State for Foreign and Commonwealth Affairs, XP World Development Movement Limited 1995, where WDM was granted standing to challenge the unlawful use of foreign aid precisely because of its expertise and the importance of the issue. Key considerations for the court. When balancing the various factors, the courts generally look at four things to ensure that judicial review is used appropriately and not simply to harass public authorities. The seriousness of the alleged illegality. The more profound the alleged breach of law, the more likely the court is to grant standing to a less affected claimant. Whether anyone else realistically could challenge it, if the alleged breach is serious but affects a vulnerable or diffuse group, example for the homeless, the court is more likely to allow a proxy challenger, like a relevant NGO, to proceed. The context and subject matter is important as well. Standing is assessed differently depending on the area. Environmental, planning, or human rights cases are often viewed through a more liberal lens than, say, routine commercial licensing decisions. And whether the claimant brings value, does the claimant provide genuine value through expertise, knowledge, or representation, enhancing the court's ability to hear the case fully? This factor supports NGOs. Lastly, we will take a look at the comparative approach, the Australian Special Interest Test. To conclude my section, I will compare the UK's approach with that of Australia, another major common law jurisdiction. The UK's Sufficient Interest Test is generally regarded as liberal and flexible, focusing on the public benefit of the challenge. In contrast, the Australian High Court, following the seminal case of Australian Conservation Foundation Incorporated v Commonwealth 1980, adheres to a stricter special interest test. The key differences are the threshold. In Australia, the interest must be special and different from that of the ordinary member of the public. This means merely having a philosophical or intellectual concern, even one driven by a genuine commitment to a cause, is generally insufficient. Another key difference is NGO challenges. While UK courts readily accept NGOs with expertise like the World Development Movement, Australian courts are more cautious. For an NGO to gain standing, it often needs to show that it is affected by the decision in a way that is unique to its operations, perhaps by being denied funding or facing direct impact on land it owns or uses. Another key difference is the consequence. The Australian test is considerably more restrictive. It focuses heavily on the claimant's relationship with the subject matter of the litigation, rather than just the illegality itself. This makes it harder for pure public interest litigation to succeed in Australia than it is in the UK. In summary, the UK test is flexible, moving from a strict private law injury model to a context-dependent public law enforcement model, where the merits of the challenge and the nature of the claimant are inextricably linked. This makes the UK a significantly more permissive environment for public interest challenges than jurisdictions like Australia. Thank you.
Hello, my name is Amna, and now we're going to walk you through how public interest standing has evolved in UK judicial review, how we moved from another identity-focused approach toward a more flexible understanding, and then back again toward restriction in the recent year. Law-double interpretation of the sufficient interest in the IRS articulates the conceptual basis for public interest standing. A claimant may not be enforced personal right, but challenging a decision because it raises whether public or rule of law concern. But the court struggled to adopt this principle, and this difficulty is reflected in the inconsistency of the LOCUS law. We see this immediately in the RV Secretary of State for the Environment. Ex parte wrote Peter Trusco 1990. The climate was a group to protect an archaeological site in the archaeological site. The High Court held that they had no personal stake and could not manufacture standing simply by forming an association. Shem Manji applied the sufficient interest test, knowledge rejecting cultural or public significance as enough. This reflected judicial concern about opening the floodgate to pressure group. This to pressure group legislation and reinforce an identity-based and direct consent model for standing. RV Secretary of the State for the Environmental XB Chandra 1997 pushed the logic even further. A complete stranger attempt to challenge an environmental decision. The Court of Appeal held that there were directly affected parties exist and remain silent, and unaffected observer cannot interfere. Again, standing depends less in the seriousness of illegality and more in the climate identity. As Strager later observed in standing legitimacy and administrative law, this created an identity-sensitive doctrine. This sit uneasily with deep block emphasis of the rule of law. Child Property Action Group, the Secretary of the State for Social Security 1990, marks the first significant judicial engagement with public interest consideration. The case remained controversial because it implicitly recognized public interest value, yet reviews standing, exposing the tension between legality review and institutional quotation, where the court acknowledged CBAG's practical role, expertise, and statutory engagement, and recognized that the no directly affected individual was likely to challenge the issue. Nevertheless, standing was refused because judicial review challenged a specific exercise of power, not the whole administrative system, and there was no directly affected member. The claim was treated as too general, showing that the identity-based filter persists. The first real breakthrough came in RV Inspector of Pollution XB Greenpeace 1995. O.T. John granted standing because Greenpeace demonstrated strong expertise, organizational capacity, and more importantly, members living in the affected area. While this remained an identity filter model, it marks the beginning of a more pragmatic phase. NGOs could obtain standing if they showed technical competence and genuine representational legitimacy. The transformative moment came with the RV Secretary of the State for Foreign Affairs, XP World Development Movement 1995. The Bragg Dam case concerns the unlawful allocation of public funds with no identified individual victim. Rose LG held that standing should depend on the series of the illegality, the suitability of the climate, and the absence of any alternative challenger. This shifted the doctrine toward a legality-centered and rule of law-based approach. This decision was constitutionalized in AXA General Insurance Ltd v. Lord Advocate, 2011. The Supreme Court emphasizes the purpose of standing is to uphold the rule of law, not merely to protect private rights. A climate interest matter only insofar as to show they are suitable person to bring the case. A scholar like Greg knows that note in administrative law, WDM broadened the standing and AXA grounded the development in constitutional principle. Together, WDM and AXA marked a shift toward a functional public interest conception of standing without removing the relevance of climate identity. However, the liberalization created uncertainty at the boundaries. Some NGO began using judicial review as political arena, and courts became increasingly concerned about separation of power inflection. The tension became clear in Good Law Project v. Prime Minister 2022. The Court of Appeal had already suggested that whether a complete stranger to a procurement process could have standing was ripe for review. Then the High Court in Good Law Project v. Minister of the Cabinet, Office 2022, narrows the doctrine. GLB could not rely on board mission statement. Group must act within their areas of expertise. or represent an identifiable affected group. The court insisted that GLB did not have a carte blanche to bring any public law claim. While it does not reverse YWM or AXA, it could limit the contractual and merits-based flexibility that this decision had introduced. As Gorgon noticed in Accountability Standing and COVID-19, GLB raised a risk of retrenchment, removing the identity-sensitive logic seen in both Creator and Chartering. This contrast sharply with Canada. The Supreme Court of Canada apply a flexible, purposive three-stage test established in the Council of Canadians with Disabilities 2022. When the issue must raise a serious judicial question. 2. The claimant must have a genuine interest. 3. The litigation must be a reasonable and effective way to bring the issue before the court. Canada test balances judicial restraint with both public interest accountability. It avoids both extremes: unrealistic access, and rigid identity-based exclusion. However, its flexibility can create unpredictability and grant judge significant discretion, raising a concern about institutional limits and separation of power. Every jurisdiction ultimately sacrifices something. A restrictive model like the UK protect judicial naturality, but risks preventing legitimate challenges to unlawful government action, while a flexible model like Canada's enhance access to justice, but introduce uncertainty and doctrine instability. No system fully avoids this trade-off. Each must choose what to base the burden.
Malaysia's approach to LOCUS STANDI initially mirrored the early strict model that the UK used. Of course, inherited the narrow common law requirement that a claimant must show a direct personal rights or special damage before being allowed to challenge government action. Judicial review in Malaysia, much like the early UK position, was viewed mainly as a mechanism for protecting private interests rather than addressing broader question of public accountability. Because of this, public interest litigants were routinely turned away. One of the most well-known examples is the Government of Malaysia v. Lim Kit Siang case in 1988. Here, the federal court held that Lim Kit Siang had no standing to challenge the award of the North-South Expressway contract because he could not show he had personally suffered any legal harm. This decision reinforced the message that Malaysian courts at the time were unwilling to entertain challenge brought purely to address public wrongs or potential governmental illegality. However, Malaysia's constitutional framework eventually created pressure for change. Our federal constitution protects a wide range of fundamental liberties, including rights relating to life, personal liberty, equality, and property. Many constitutional disputes that do not involve individualized damage in the traditional private law sense, but they still raise serious questions about legality and state power. As rights-based and constitutional litigation increase, it becomes clear that a rigid and narrow approach to standing could undermine the very purpose of having constitutional guarantees in the first place. Courts gradually recognized that meaningful judicial oversight requires more flexible access to judicial review. By the late 1990s, Malaysian courts began taking a more liberal, purposive, and context-sensitive approach. A good example is the Majlis Perbandaran Pulau Pinang case in 1999, where the federal court accepted that standing should be granted whenever there is a genuine legal controversy that requires judicial determination. In later cases, especially those involving constitutional rights. Courts accepted that a claimant may have standing wherever they raise a credible issue of legality, abuse of power, or constitutional inconsistency. Although the shift has been gradual and cautioned, Malaysia has clearly moved away from the rigid personal right only model and toward a more open understanding of private law supervision. When we compare both jurisdictions, several similarities and differences become clear. Like Malaysia, the UK also began with a highly restrictive rights-based model that made it difficult for the public to challenge unlawful government action. Both systems eventually recognized that this strict approach created unacceptable gaps in the rule of law. Because many public wrongs do not injure any single individual in a clear and direct way, however, the UK reformed much earlier and much more decisively with the adoption of the sufficient interest test in the IRCV National Federation of Self-Employed case. This new test opened the door to a wide range of public interest challenges, including claims brought by NGOs, advocacy groups, and representative organizations. Malaysian courts, in contrast, have expanded standing more slowly and often only within constitutional or right-based contexts. Malaysia remains more cautious, placing greater weight on judicial restraint and the separation of power. In conclusion, standing plays a central role in determining who can bring issues of legality before the court. Both the UK and Malaysia have to navigate the delicate balance between preventing frivolous or political motivated claims and ensuring that unlawful government action does not escape judicial review. The UK's approach is now more liberal and publicly accessible, while Malaysia is gradually moving in that direction as courts engage more deeply with constitutional principle. Ultimately, both jurisdictions recognize that access to judicial review must be broad enough to uphold the rule of law, but carefully controlled to maintain the proper functioning of the legal system.
Conclude, standing is essential for judicial review. It decides who can go to court and ensures court deal with real problems, not pointless or political cases. In the past, the UK only allowed those directly harmed to bring claims. Later, the sufficient interest test allowed public interest groups and NGOs to challenge government actions, provided they show a real link and can contribute meaningfully. Public interest standing is not automatic. Claimants must be credible and serious. For example, in Inland Revenue Commissioners and National Federal of Self-Employed and Small Businesses 1982. The court allowed a public interest group to challenge government action because no one else could be realistically bring the case. Other countries like Malaysia started strict but have gradually opened up to public interest litigation, especially in the right of constitutional matters. In short, standing acts. To conclude, standing is essential for judicial review. It decides who can go to court and ensures Court deal with real problems, not pointless or political cases. In the past, the UK only allowed those directly harmed to bring claims. Later, the sufficient interest has allowed public interest groups and NGOs to challenge government actions, provided they show a real link and can contribute meaningfully. Public interest standing is not automatic. Claimants must be credible and serious. For example, in Inland Revenue Commissioners and National Federal of Self-Employed and Small Business 1982, the court allowed a public interest group to challenge government action because no one else could realistically bring the cases. Other countries like Malaysia started strict but have gradually opened up to public interest litigation, especially in rights or constitutional matters. In short, standing acts as the gatekeeper of judicial review. It protects the courts, ensures only genuine cases proceed, and allows serious government wrongdoing to be challenged. It shows how law balances justice, access, and practicability, which is core of the understanding standing today. Thank you for listening. We hope this presentation has helped you understand the importance of standing in judicial review.